Okay, welcome. So I'm Nick Rosencrans, and I'm delighted to be here moderating the Young Scholars panel. I think this is one of the most important things that the Federalist Society does, try and help develop the work and the scholarship of young scholars. So I'm particularly happy to be here. I'm just going to introduce our speakers and tell you a bit about the format, and then we will get going. We have four very impressive young scholars here today, and then two more senior commenters who will be commenting on their work. I'm going to give you very abbreviated bios for these impressive folks. You should look online to see all their accomplishments. Our first young scholar is Will Baude. He graduated from the University of Chicago and from Yale Law School. He clerked for Judge McConnell in the 10th Circuit and for Chief Justice Roberts at the Supreme Court. He's currently a fellow at the Constitutional Law Center at Stanford Law School. Second is Dan Markel. Dan graduated from Harvard College and Harvard Law School, and he also holds an MPhil from Cambridge. He clerked for Judge Hawkins on the 9th Circuit. He's now the Delambarte Professor of Law at Florida State University College of Law. Third is Andrew Schwartz. Andrew graduated from Brown and then Columbia Law School. He clerked for Judge William Fletcher of the 9th Circuit and for Judge Naomi Reese Buchwald of the U.S. District Court for the Southern District of New York. He is currently an associate professor of law at Colorado Law School. And fourth is Houman Shadab. He graduated from UC Berkeley and USC Law School. He's now an associate professor and associate director of the Center for Financial Services Law at New York Law School. And so those are our four young scholars. We have our two more senior commenters. Our first is Eugene Volokh. It's, of course, impossible to do justice to his resume in an introduction, and I suspect you all know him well in any case. Just to mention some highlights, he graduated from UCLA College and Law School, clerked for Judge Kaczynski on the 9th Circuit, Justice O'Connor at the Supreme Court. He's published a vast amount of scholarship. He's also the lead conspirator of the widely read blog, The Volokh Conspiracy. He's the Gary T. Schwartz Professor of Law at UCLA School of Law. And our second commenter is Todd Henderson. Todd's a graduate of Princeton and University of Chicago Law School. He clerked for Judge Dennis Jacobs of the U.S. Court of Appeals for the 2nd Circuit. He's a leading scholar in the fields of corporations, securities regulation, bankruptcy, law and economics, and intellectual property. He's now a professor of law at the University of Chicago Law School. And I should just say we're particularly grateful to Todd for joining us today because he agreed to step in at the last moment after the tragic and untimely death of Larry Ribstein, who would have been here today. He was a great friend and mentor to many of us, including Todd. And so Todd, I wonder if you'd just say a couple of words about that.
Yeah, thank you for that introduction. I feel very awkward being here under these circumstances. I'll do my best to fill Larry's very big shoes. I was watching the 60 Minutes piece about insider trading on Capitol Hill and saw that everybody was aligned that this is a really bad thing and we need to stamp it out. And seeing that 60 Minutes and everybody else thought it was wrong, I knew it had to be right. So I started thinking about why it would be fine to have congressmen trading on inside information and why the regulations and attempts to solve it would be completely a sideshow and just political theater. And I thought, well, maybe I should write this into an op-ed. And so the first person I thought to call to talk about this was Larry. And I called him up and I said, hey, Larry, do you want to talk about insider trading by politicians? And I don't know what he was doing at the time. But of course, the answer was yes. 100 times I've called him with things like this. And the answer was always yes. Larry didn't know me. We didn't have a prior relationship before a couple of years ago. I have no affiliation with Illinois. And he spent countless hours mentoring me, guiding me, criticizing me, raking me over the coals, telling me when I was completely wrong, and offering me an enormous amount of love and care as one scholar to another. So he will be missed by me personally, and I know many of us. So I would just encourage you to do two things. First, go read Larry's work, which is one way that he will live on. And the other is try to live up to his approach to the legal academy, which is he was iconoclastic, he was incredibly caring, and had an absolute dogged zeal in pursuit of truth about the world. So we will miss you, Larry.
Todd, thank you so much for that, and thank you for being here and stepping in at the last minute. So our format here is the scholars to my left are primarily public law scholars. And so what we'll do is each of the young scholars in public law will do a 12-minute presentation, and then Eugene will comment on their work, and then we'll have the private law scholars speak, and Todd will comment on their work. So without further ado, we'll get started, and we're going to start with Will Baude.
Here we go. Is this working? Section 3 of the Defense of Marriage Act, called DOMA, provides that in determining the meaning of any act of Congress or an administrative ruling or regulation, the word marriage means only a legal union between a man and a woman.
I'm sorry, can people hear him back? Okay.
We good?
Sorry, I put the mic down.
Okay, is that better? As husband and wife, and the word spouse refers only to a person of the opposite sex. DOMA has become controversial. The executive branch has argued that DOMA is unconstitutional, and several courts have agreed. And if the trend continues, DOMA may well be invalidated or repealed soon. So my paper argues that it's time to think about what will come in its place. Federal law frequently looks at whether or not a couple is married. That's the kind of thing Section 3 of DOMA regulates. And the executive branch and the courts have been assuming that once DOMA is gone, the federal government will just rely on state law to see who is married. After all, marriage is primarily a creature of state law. But states have different rules about who can get married, and as I'll explain, it will frequently be unclear which state's law to rely on. More than 100,000 same-sex couples report being married, and many of those marriages end up crossing state lines. We need a federal choice of law rule to tell us which state's marriage matters. Without one, DOMA's demise may lead to chaos. So with my remaining time, I'll first explain the problem, and then I'll argue that there's a solution. First, it's very possible, it's even likely, that DOMA will be held unconstitutional, but that states will still be permitted to ban same-sex marriages, at least in the short run, and maybe that short run will be pretty long. DOMA's challengers and the courts that have invalidated DOMA have not been arguing that there's a constitutional right to same-sex marriage. Instead, they've argued that even if states can make their own decisions about same-sex marriage, the federal government is required to respect that state's choice. There are sort of several doctrinal ways the argument gets framed under intermediate scrutiny and rational basis scrutiny, but the basic argument is that states may well have a tradition of limiting marriage to opposite-sex couples, but the federal government doesn't actually have one. Instead, what it's been doing is looking to state law to decide whether or not a couple marriage is valid, whether or not a couple can get married. And even today, aside from issues of same-sex marriage, it still largely looks to state law. When it asks whether the couple was old enough, did they have the right kind of officiant, are they too closely related, was one of them already married to somebody else and failed to get divorced. So the attacks on DOMA have a federalism angle. And whether or not you agree with those constitutional arguments, they seem to be the ones that are gaining momentum. And if they win out, the question will be, what's next? The same sort of problem arises if DOMA is repealed instead of invalidated. So, what's next? The first problem, as I said, is that states have different rules about whether same-sex couples can get married. The second problem is that states don't even agree among themselves about which state's law controls for a given couple. So take the example of a couple that gets married in a same-sex marriage state, then moves to a state that doesn't allow same-sex marriage. Sometimes, if the state is Maryland or Rhode Island, the couple will still be treated as married, even though same-sex couples can't get married in that state. Other times, the state will say they're not married anymore. So there's a real example. Two men get married in Massachusetts, then they move to Texas, then later on they decide they want to get a divorce. Texas won't even allow them access to divorce court to figure out who owns property and sort of make a judgment about their rights to one another, because Texas says they're not married in Texas and we won't have anything to do with it, even while Massachusetts continues to say they're married. And in many other states, it's not even clear sort of which side the state will take on these kinds of controversies or whether it'll take a consistent side. Now, in a sense, this is not a new problem for the states. People have been getting married and moving around for a very long time, but there's just never been widespread agreement about the solution to that problem. Most of the time, states defer to the place where the marriage was celebrated, but sometimes they don't. So then what's the federal government supposed to do about this? If it's true that the federal government usually looks to state law, well, what does it usually do when the states disagree about these issues? And the answer is that's an even bigger mess. Over the course of the 20th century, when the federal courts confront this problem, they've already adopted at least 3 different approaches. One is based off of a Supreme Court case called Klaxon, which says that in cases in diversity jurisdiction, you apply the choice of law rule of the state where the district court is physically located. It's nothing to do with anything about where the parties were married or sort of anything about the actual facts of the case other than where was the lawsuit brought. You sue in New York, you apply New York choice of law principles. A second approach that some courts have applied is just to make up their own choice of law rule as a matter of so-called federal common law. Good news is that gets you away from this kind of formalistic rule that's just based on the forum where you sue. But the bad news is now you have to come up with a rule. And it's not as if there's a single rule that all the states apply. And the third approach some courts have used, although this is probably the least common one, is to sort of give up on using state law altogether. So if a federal statute says marriage, federal courts just decide on their own whether the couple should be married or not, without regard to whether they were married in that state or any of the relevant states. So federal courts are all over the place, and the Supreme Court has never stepped in. Individual circuits sort of waffle back and forth with different approaches. And as a doctrinal matter, this isn't just about marriage. I mean, this happens anytime federal law draws upon a state law concept. Sort of all these different approaches fight out with one another. So DOMA has been suppressing this big choice of law problem in the same-sex marriage context, and if it goes away, we'll suddenly have to answer it again. The last part of my paper offers sort of my own tentative thoughts of what to do. But in my view, what to do also is related to who does something about it. So Congress could fix this problem by providing a statutory rule. I mean, one of the bills that's been proposed to repeal DOMA contains a rule. So it would say, you just look to whether or not the marriage was valid in the state where the couple got married. International marriages are sort of more complicated. A congressional choice of law solution is good. It has more legitimacy than a judicial solution. And it can sort of legitimately consider a broader range of policy considerations. So I think the rule Congress has proposed makes a lot of sense. I think it sort of allows couples to have a certain amount of stability. They know that when they get married, they'll stay married no matter where they go. And I think similarly, the executive branch could try to engineer something like that as a matter of coordinated agency action or an executive order. But in practice, I don't think we should hold our breath for either of these things. Conflict scholars always complain that Congress or the executive branch should step in and provide more guidance in a bunch of choice of law issues, and it basically never happens. So it's not necessarily a reason to believe this will be the first time. So then this might fall back to the courts. And out of the 3 approaches I discussed a second ago, I think the one courts have to do is to create one as a matter of common law, even if that's a second best option. This is risky because the whole point of getting rid of DOMA is to get the federal government out of making value-laden decisions about same-sex marriage, but I don't think it can be avoided. The problem with the Klaxon rule is that it assumes there's been a lawsuit. That's the one fact it uses to decide what rule to use. And most of the time, federal law is applied and enforced without there being any lawsuits at all. It happens by the executive branch, it happens at administrative agencies, and there may never be a lawsuit and you won't know where it would be. So that's not going to work as a rule to sort of work across all of federal law. And the approach of ignoring state law altogether and having sort of courts just decide as a matter of independent federal law whether you're married requires courts to make up a federal law of domestic relations, which is no easier than making up a choice of law rule, in fact a lot harder and not something they're really equipped to do. So we need a common law rule. Then the last question is what common law rule? And here I think the goal should be for courts to be as value neutral and to leave as small of a footprint as possible. So in the paper I argue that the rule that does that best is to look at the choice of law rule of the couple's home state, their domicile. So if the same-sex couple lives in Massachusetts or Maryland, you look at Massachusetts or Maryland law, both of which would say, we'll recognize a same-sex marriage. If they live in Texas, you'd say they're not. You sort of treat them for federal purposes the way they're treated at home. There are, of course, arguments that federal law should guarantee a constitutional right to same-sex marriage, but that's sort of a choice of law rule is not the right place to do that. That should be done through constitutional interpretation, if at all. Another argument for my domicile rule is that there are a couple of scattered statutory provisions that do deal with marriage. There's one that regulates some of Social Security and one that regulates some veterans' benefits. And if you're a court, those are a couple of guideposts you have, and it makes more sense to fill in the same rule around them rather than to try to invent some new rule you think might be better that will then create a statutory conflict. Now, you could sort of agree with much of my analysis of the problem and still think my common law rule is not the best one. I think that's sort of the hardest problem, and to some extent it's inevitably one that's subject to debate. But the most important point of my paper is that there's going to have to be a rule, and if the political branches don't supply it, then the courts will have to. So the paper is called Beyond DOMA, and the last thing I want to say is that, as I mentioned, this is a problem that may become particularly acute in the same-sex marriage context, but it's really a bigger conflicts problem more broadly. There are tons of areas where federal law draws upon a concept under state law: property rights and tax and bankruptcy, other domestic relations issues in Social Security and immigration and elsewhere, even criminal law. And Congress very rarely provides choice of law rules. So the goal of my paper is to provide a framework for those areas as well. Congress can and should provide choice of law rules in as many of those areas, or maybe even all of them. But if it doesn't, the federal courts will have to create them. Federal courts can't use something like the Klaxon rule, even though it sort of offers a neat and concrete solution. Instead, they have to create one as a matter of common law, and they have to create common law in a way that's different from what a legislature would do. So if the demise of DOMA does bring chaos, hopefully the chaos will eventually bring the creation of a new framework for interpreting federal law more broadly. Thank you.
Thanks, Will. Our second speaker is Dan Markel, speaking about retributive justice and the demands of democratic citizenship.
Greetings, everybody. Thank you very much to Nick and to Eugene and to Todd and all of my co-panelists, as well as to the wonderful folks at the Federalist Society who have been so exceedingly generous to me over this last year. It's an honor to be here and share some thoughts with you about this big project that I've been working on this last year. It's unfortunately an incredibly and exceedingly long piece, and unfortunately Eugene got tasked with reading about the 130 pages of it. So it's probably going to become the basis of a book, and I look forward to getting your thoughts about it. And let me just sort of give you a few of the bullet points of the argument, and then if you have questions or want to follow up later, you can find me and or download the paper on SSRN. So the paper is about the tissue connecting democratic citizenship with retributive justice. And the argument is that contrary to some of the leading criminal law theorists like Michael Moore or Doug Cusack, who insist that in order for the criminal law to be retributively just, it has to be predicated on moral wrongdoing, I argue that we need to, or that we can, as retributivists, loosen up on the criminalization question and move beyond the insistence on moral wrongdoing as a prerequisite for justifying retributive punishment, at least in liberal democracies. And that qualification of at least in liberal democracies is really quite important. In addition to the thesis that there's more flexibility in terms of what plausibly justifies retributive punishment than simply the existence of evidence of moral wrongdoing, I also argue that retributivists have to show some respect for democratic lawmaking when it applies to sentencing, but the sentencing issue is distinct from the criminalization question. And if I'm right that there is some kind of way in which democratic authority can generate new moral obligations for citizens, then there are at least some counterintuitive implications that arise. And I'll tell you what they are. So first, it seems to me that as a matter of moral obligation, which is to say non-prudential reasoning, we are morally obligated to obey not only laws that seem quite obviously correct, mala in se laws that are obviously liberalism compatible, laws that would ban, say, rape or murder or robbery, but also what I call dumb but not illiberal laws. And that said, there are actually two kinds of laws that we are not morally obligated to treat as an independent reason for action. Those laws which are spectacularly dumb, as opposed to the permissibly dumb, and those laws which are illiberal. Now, if I'm right that there's more leeway for democracies in sort of carving out a space of what might be called the permissibly dumb laws that might bind us in criminal, vis-a-vis the criminal law, then there's a slightly peculiar upshot of that when we think about this from a comparative perspective about what regimes are able to do. And that's to say that within liberal democracies, I argue that that the scope of conduct that's legitimately criminalized and justly punished is larger than what would be justly punished in bad or wicked regimes that are not liberal democracies. So that's the sort of the core thesis. Now, I don't plan on sort of showing you much of the scaffolding behind those claims, but I'm happy to sort of at least cash out a few of those with some examples so that you can get a better sense of where my thoughts are. So one of the things that I had been working on, I guess I've been working in the realm of punishment theory for the last dozen years or so, and I've always been one of these punishment theorists who, rather than focuses simply on the moral question, also looks at the political theory issues associated with punishment as a state institution. Now, what I hadn't done before is sort of give a whole excursus, I guess, on, or extended disquisition on sort of what is the nature of our political obligations. And so the first part of this very lengthy project is to sort of go in and sort of see to what extent democratic authority can really change our moral obligations to the law. And so I end up weighing in with, against the sort of trendy move in the literature to be a philosophical anarchist, and I sort of throw my lot in with, for the most part, with the folks who, like Scott Shapiro is one of them, and in the philosophy world, people like Cristiano, people who are sort of skeptical of this philosophical anarchist tradition. But although I believe that there is something to be said about the nature of democratic authority, I do think that there are obvious limits on its ability to create new moral obligations for us as individuals, as citizens. And so the issue is not so much whether there's a content-independent moral obligation to conform to the law, because I don't really think it makes sense to think about moral obligations as ever being content-independent. But the question is, what scope of the content is likely to trigger a moral obligation and what scope is not? And so what I try and do is use these ideas of like what counts as permissibly dumb but not illiberal to versus illiberal versus spectacularly dumb, to try and sort of draw some categories about what kinds of laws might fit in. And I'll just, so in parts 2 of the paper, I sort of say, well, here's what I think from a political retributivist perspective as opposed to a moral retributivist perspective. Here's what I think the potential for us to, what would count as a legitimate criminal law, we could count as the things that the negative legal moralists would think are important. The folks like Moore and Husak said, like, well, we got to focus on moral wrongdoing only. I think that's a perfectly legitimate and usually quite attractive approach to thinking about the criminal law, but I don't see why a liberally constrained social welfare approach to thinking about harm reduction would necessarily be in tension with a retributive justification for punishment. Now, I realize that that seems somewhat peculiar to people, but I hope the paper is able to flesh out that intuition a little more clearly. So let me give you some examples of what I think fall under under these kind of labels that I've been using. So murder, for example, is a kind of law that I think everyone agrees on. It would count as a necessary feature of any criminal law to be just. You'd have to have a law like that. There's an interesting question about drug possession, gun possession, possession of burglar's tools, right? So these are all things which are not, in the language of my interlocutors, folks like Moore and Husak, which the possession of which is itself morally wrongful, right? The question is that those are often sort of risky or thought to be somewhat risky in terms of their likelihood to endanger other folks. And so my view is that that would fall under the realm of, they could be smart laws, they might not be smart laws in terms of whether they are effectively going to diminish these kinds of risks. But my view is that for the most part, prohibitions on the possession of those kinds of things, burglars, tools, guns, or drugs, would fall within the realm of the permissibly dumb. Whereas something like a prohibition on chess, right, at all time, for which there would really be no way you could offer the grounds of what I would call like it's a tweaked version of rational basis with bite scrutiny. A prohibition on chess, a criminal law that would ban chess, strikes me as lacking any possible rationale. Now, the drugs, guns, and burglars tools, so the moral retributivists would say, well, those are all not really morally wrongful. We shouldn't have criminal laws condemning that behavior. You can have regulation. And I try to explain why the regulation approach is, probably preferable, but nonetheless not something that is required at the exclusion of the criminal law from weighing in on some of those things. And then there's other examples that I go to, such like eating on the subway, right? That's here we are in DC, where eating on the subway has at times led to people being criminally liable. And I argue that that would actually also fit within the permissibly dumb, but it's not spectacularly dumb. And so those are my intuitions, and I try and flesh out what the significance is. But the fact that something is permissibly dumb is only the beginning of the inquiry, right? So it might be the case that what we need to do in terms of sentencing is look at whether something passes a rational basis with bite scrutiny, as I call it, in order to warrant a very, very light penalty. But if you wanted to impose a more substantial penalty, I argue that we should actually have the moral equivalent of a tiered approach, such that the more punishment you wanted to impose on someone for a particular kind of conduct, the more intense the scrutiny we owe as citizens or as officials to the underlying prohibition. So it seems to me that drug possession itself could be plausibly criminalized under this approach, but it would not be something that could trigger substantial punishment. Thanks. On the other hand, theft or rape or murder, right, those would be the kinds of things that I think could withstand even the moral equivalent of strict scrutiny, and so more intense punishments like incarceration would be appropriate. Now, I do think that there still needs to be some second approach, in addition to this kind of tiered scrutiny approach. There needs to still be some kind of compatibility with what I think of as good retributive values, but as I try and articulate in the paper, there's got to be a little bit more play in the joints for democracies than I think retributivists have been willing to acknowledge in the past with respect to these kinds of sentencing questions, as well as the criminalization questions. So the last point I'll sort of circle back to, something I alluded to at the beginning, which is not only what our obligations are as citizens in terms of whether we have obligations to conform to these laws, but also whether we have obligations to assist law enforcement, or whether as officials we have permissions or pro tanto obligations to enforce the permissibly dumb laws. So my argument in the paper is that if a law is permissibly dumb, but not illiberal, then that creates what philosophers call a pro tanto reason for you to enforce it if you're an official. Now, it can be easily canceled or overwhelmed by other considerations, but the fact that there is a law on the books within a liberal democracy that satisfies the kind of preconditions of inclusion in the political process, in those cases, I think that there's a good argument available for thinking that more discretion to officials is not actually appropriate in all sorts of instances. And similarly, even with permissibly dumb but not illiberal laws as citizens, I think we have certain moral obligations to render what I call reasonable assistance to law enforcement when we see violations of those permissibly dumb laws. Now again, those are pro tanto reasons. They can be kind of overwhelmed under the circumstances, but I do think that the fact of there being a law within a liberal democracy changes what our moral obligations might be, at least with respect to the permissibly dumb. Now, so that's kind of the conservative. I guess I've always wondered why the Federalist Society has been supporting my work, but I think there is a quasi-conservative aspect to this paper as well as a very radical aspect. And the conservative aspect is that it seems that there's a whole range of laws to which we owe some kind of conformity to the law. and reason to help out with law enforcement. On the other hand, if you sort of have good reason for thinking the law is illiberal or spectacularly dumb, it actually forces you to act in some ways in contravention to the law when you would otherwise be required to act illiberally towards someone or with a spectacularly dumb basis, which is to say with a totally unreasonable basis. So I'll stop there because I've already gone on, but I'm happy to answer questions later, and hopefully this will provoke some conversation. Thanks.
I want to thank Will and Dan very much for their very interesting papers. I have some comments, mostly addressed to Dan, but let me begin with ones to Will. I liked your paper a lot. I thought it was very interesting and helpful and clear and well-reasoned. My main suggestion would be to talk more about federal law. Federal law, excuse me, about foreign marriages. So a couple married in some country, or perhaps more than a couple, several people married in some country, come to the United States for a visit. One is arrested. The question is whether another can testify against them. And I've long thought this is the single most important benefit of marriage. For most of us, we don't take advantage of it. But for those who do, it's much more valuable than most of the others, and that benefit is being able to give citizenship to your spouse. If you look at all of the tax benefits out there, all of the various other things, the testimonial privileges, and that's nothing compared to the ability to marry someone you want and then have them be able to live and work in the country. Yeah, that's something to which the state law questions will not always offer an obvious answer. I think that would be interesting to talk about. Another thing that I wish there had been a little bit more discussion of is the possible objections to the statutory proposal, which is that the statutory proposal would be that Congress essentially make marriages valid pretty much, oversimplifying, but pretty much they're valid in the place of celebration. Which means, as Will points out, since most people choose to marry in a place where it's legal, and since it's easy to travel now to a place where it's legal, that means that it will be err in favor of recognizing the marriage. There'll be lots of people living in Texas who are federal law married but not state law married. That need not be bad, and it may be better than the alternative, which is that the same couple, as they move from Massachusetts to Texas to Iowa, will be married, not married, married. But still, it might be interesting to think what the possible implications are. Where are there areas where federal and state law operate in the same scheme? What about, I don't know, Parental Kidnapping Prevention Act? I don't know if it actually focuses on marriage. Maybe it doesn't. But some of those kinds of schemes, how they would interact with, say, state family law systems. I would have liked to see that. I also thought, and I think given the way that the teaching market operates these days, this is, I think, especially important. People are looking for not just articles that solve a particular problem really well, but also shed light on broader things. And I think this article was helpful because in part because it deals with a broader question, which comes up in copyright law, in tax law, and a variety of other areas of law, which is what happens when you need to rely on state law to figure out whether a contract is valid or something like that, in order to solve a problem for federal law. So federal copyright law specifies the consequence of assignment of copyright, but it's pursuant to contract, and there's state law of contract. There's a brief discussion of this at the end of the paper. I would have liked to see a little bit more of a discussion, perhaps with just some examples of how you might tentatively suggest how your thinking in this paper might point in that direction, point towards the solution of those problems. The one last thing, and I know this is controversial, but I thought I would just mention because I know there are other juniors in the junior faculty members in the audience and would-be faculty members, and I've always thought that this panel was in part about conveying ideas about that. Different people have different views on this, but I think this is the kind of talk that would benefit a good deal from some PowerPoints. If you have a three-part test, it seems to me there should be a PowerPoint with 3 prongs. Not necessarily the full text of the test, but a little item. If there are 3 different approaches, there should be a slide with 3 different things. Just because it's otherwise easy for people's attention to wander. I think if you're giving them the audio and the visual at the same time, more likely they'll focus. I know people disagree, and I know PowerPoint has often been abused, but I think that would be my recommendation. Now, turning to Dan, I thought this was a very interesting paper, and I think part of it is right, and non-trivially and importantly right, that if you think that there's some moral significance to democracy, then it seems to me democratic choice can impose obligations on its citizens in complicated ways that just simple platitudes about consent, let's say, don't really answer. I thought this paper was very helpful for that. Let me just point to several specific thoughts that I had. One point that the paper says is that the obligations to follow the law, but also not to enforce certain, the very dumb laws, apply equally to government officials and to citizens. And I want to probe a little bit on that. If there is this law against playing chess, I would tend to agree that a police officer would be perfectly justified, in fact would be more justified, in turning a blind eye to the law, to the violations of the law. Likewise, I think if a prosecutor chooses not to prosecute, I think that's fine. If a judge, without holding the law unconstitutional, because your point is not about constitutionality but about obligation, just says, I choose to dismiss this in the interest of justice, I'd be much more skeptical. And if a prison warden just decides on his own to let out everybody who's in prison who's guilty of violation of the law, I would think that's very bad. Maybe I'm wrong. I'm not sure I can fully articulate why I think this. But it seems to me that it would be helpful to talk more about it. I hesitate to say talk more in the context of it was 130 pages long. You know, this may be its natural length. The difficulty is it's hard to get people to read 130 pages. But it seems to me that was something that struck me as under-defended. Also, the assertion that if somebody has a duty to obey dumb but not very dumb and not illiberal laws, they also have a duty to help the government enforce that, struck me as not clearly proven. One could say, look, I have a duty as a citizen to follow the law. Even if the law is wrong, my disobeying the law is wrong. But if Will then has to decide whether to turn me in, he sees me violating this law, he agrees it's dumb but not ridiculously or liberally so, why should he assist the government in the wrong of enforcing this dumb law? It doesn't seem to me clear that this would be so. One practical argument that you give, which I think is a powerful one, which is that for reasons of social cohesion, social functioning, it's bad if every person feels that they should be free to disobey any law they like. I tend to agree with that. I'm not sure that that applies to every person feeling free not to call the police when they see a violation of a law that they think is a dumb law. Also, it's possible that the refusal to cooperate, not refusal to, say, testify in court when you have a legal duty to do so, but refusal to just simply cooperate, it's possible that that might send a useful signal to the government about which laws really have lost the support of the public. Now, there are a couple of other things that have to do with situations where you think that the law is so illiberal as to be not binding, and the consequence of that. One is there's an extent to say if the enforcement policy is to arrest only black men who are guilty of an offense, then at that point the police officer bears moral responsibility for what he does, which I take it suggests the police officer shouldn't do that. Well, you know, it's easy to say now, and I think it would be morally understandable to say that 50 years ago, but somebody who is in a position where they're a police officer required to do that, and today perhaps less so, there's a policy explicitly focused on black men, but there may be a policy that, for example, arrest men but not women, or throw the book more at men than at women. You may think it's wrong, but the police officer says, you know, but there are people I'm trying to help by being a police officer. So unless you think that everybody now has a duty to just refuse to be a police officer, I think there would be a pretty strong claim if somebody feels that they're doing on balance more good than harm. I'd say, look, it's a bad policy, but given that I can't just violate the rules because of the institutional structure of the department, my choice is either I just refuse to enforce this offense and let all the victims, and perhaps the victims of the black men are disproportionately black victims themselves, so leave them unprotected. I think that having morality demand that much it's not clear to me that's a moral result. Likewise, at the end you ask, does a prohibition on gay marriage or consensual plural marriage make a regime illiberal for the purposes of making permissibly dumb but not illiberal laws non-obligatory? And it's not that you think those laws shouldn't be enforced. You ask whether, in fact, because of that, your whole construct no longer applies, and people no longer have a duty to follow the instructions of the regime in general because it is illiberal in particular parts. And your answer is, I'm not sure, but I'm inclined to think the answer is yes. If that's so, then it sounds like you've produced a very interesting framework for people's duty to obey regimes under circumstances that have never existed in human history, except perhaps in the last couple of years in, I don't know, Massachusetts and Iowa, according to you, but I'm sure we can find lots of illiberal things there as well. If not now, when the next movement alerts us to various kinds of injustices. So maybe you're right, but are you sure you're right? Are you sure your approach is really that limited in scope? The last thing I want to mention is this talk of strict scrutiny. Lots of people find it useful to import strict scrutiny and intermediate scrutiny from other areas. I would suggest to resist the temptation. And that's, I know time is short. Let me just, time is out. Let me just say very briefly for two reasons. One is there are very different kinds of strict scrutiny. And then this is not just an issue for courts, but also if you would just say, you know, we should guide ourselves by strict scrutiny. Is that strict scrutiny for content-based speech restrictions, nearly fatal in fact? Is it strict scrutiny as was practiced under religious exemption regimes in the Sherbert-Yoder era, famously called feeble in fact? Which is it? But on top of that, it's also, even if you can identify each one, those are badly underdefined. Courts talk about strict scrutiny and intermediate scrutiny as if they have content. Incidentally, there are many different kinds of intermediate scrutiny. But it turns out that they often don't have much content. So it seems to me you'd be better off actually articulating things that are more tailored to your particular proposal and potentially clearer, rather than trying to kind of borrow what I think is the ill-gotten credibility that those other those labels seem to have acquired. Thank you, Eugene.
Great, thank you for that. And that's the public law side of our program today. And now we begin our private law side. Our third young scholar is Professor Andrew Schwartz, speaking about the Perpetual Corporation.
Excuse me. Thank you very much for having me. Along with you, I mourn Professor Ribstein, whose work I cite in this article, but I definitely appreciate Professor Henderson stepping in as an able substitute. So my paper is called The Perpetual Corporation. It's forthcoming this year in the George Washington Law Review. Corporate scholars disagree about a lot of things. But they all pretty much agree that the ultimate objective of a corporation is not short-run profits, but rather long-term profitability and gain. And this is clear in the case law. For example, on the question of whether a corporation may make charitable donations, the law is clear that they may do so, even though there's no immediate benefit to the corporation, because of the good publicity that will enhance profitability over time. Likewise, popular sentiment holds that corporations should be run with a long-term perspective. Just look at the widespread outrage over bankers at Lehman Brothers and Bear Stearns who allegedly caused the recent financial crisis by focusing on their annual or quarterly performance as opposed to the long-term health. But hold on a second. It may be a good practice to run a corporation for the long term, but is it a legal obligation? Well, let's go back to first principles. What is a corporation? Well, it's a legal entity, a creature of statute that possesses only those characteristics that the law or its certificate creates. So it's not enough to say that it's a good idea or it's good policy for corporations to be operated for long-term gain as opposed to short-term. Something in the law or certificate must establish such a rule, or it's not really a rule. Prior literature has not identified any such basis, leaving a gap in our understanding of the corporation. This article fills that gap by identifying the statutory source for the idea that directors and officers must manage their corporations for the long term. That source, as my title suggests, is that section of modern corporate codes that provide that corporations shall have perpetual existence, unless their certificate provides for a term of years, which they almost never do. Because a modern corporation, and this is a change from the 1800s and before, but because modern corporations have perpetual existence, they are in a sense immortal. And the only rational way to manage an immortal entity is with an eye towards the very long term. And this perpetual existence is distinctive to corporations. Other forms of Uncorporations, as Professor Ribstein would say, like limited partnerships, have limited lifespans. Private equity funds, for example, are commonly or maybe universally organized as limited partnerships with 10-year lifespans. Thus, the first point I make in this article is that the conventional wisdom that corporations must be managed for the long term does have a grounding in law, and that's the default rule of perpetual existence. In the remainder of the article, I try to explore some of the implications of this perpetual existence, specifically regarding investment choices. Because really a corporation is an investment vehicle. Shareholders buy shares and the corporation takes that pile of money and purchases assets or investments. And so, given that the corporation is perpetual, how should it go about investing its capital? Well, to answer that question, I use a thought experiment. How would an immortal investor act? Well, I suggest there are two key differences between the way an immortal investor would invest versus us mortals. First, the time horizon for the immortal investor would be very, very long. Second, the discount rate for the immortal investor would be very, very low. Let me explain each of these points. As for time horizon, a mortal investor's time horizon is limited by our lifespan, simply because you can't take it with you. By contrast, an immortal investor will never die and can invest, therefore, with any time horizon. And because long time horizons are correlated with high investment returns, an immortal investor can be expected to make long-term investments, or at least longer than any natural person. As for the discount rate, that concept is derived from the idea that we humans have an innate time preference for an immediate benefit over a delayed one. $1 today is worth more than $1 in a year from now, even when there's no risk involved, and even if there's no inflation. How much more? Well, that's the discount rate. So a person with a 20% discount rate would value next year's dollar at 80 cents right now. Well, so why do we have a discount rate? Why do we prefer an immediate reward to a delayed one? The answer ultimately is human mortality. We all know that sooner or later we're going to meet our maker. And that moment might come while we're waiting for our delayed reward. Our knowledge of this causes us to prefer the immediate reward, which we are certain to enjoy, versus the deferred one, which we might not. This basic financial concept has been the subject of countless works of poetry and literature and well-known adages like carpe diem, eat, drink, and be merry, for tomorrow we die. And it furthermore follows that our discount rate depends on, it varies from person to person depending on how likely they are to survive to the payoff period, or at least their perception of that likelihood. So a healthy teenager should invest with a low discount rate because she's very likely to collect. By contrast, my 86-year-old grandmother should invest with a relatively high discount rate. The immortal investor lies at the extreme, for he's certain to survive to collect the delayed reward. Therefore, the immortal investor should display the lowest discount rate of all. These two aspects of immortal investing, a long time horizon and a low discount rate, provide important advantages to the immortal investor. Let me just mention a few of them here. First, illiquid assets are known to offer the opportunity for outsized returns, but they are inappropriate for most mortal investors who might need the money for food or shelter, say. But immortal investors have a very long time horizon and much less need for liquidity, so they could tie up their money for a very long time. Similarly, immortal investors can invest in very volatile assets, more volatile than mortals would be appropriate for mortals. Highly volatile assets also are known to be correlated with high investment returns, but are inappropriate for people with a limited time horizon. So in this sense, an immortal investor is sort of like a young worker with always a very long distance before retirement. A third advantage for immortal investors relates to cooperation. It should come as no surprise that people prefer to transact with those they trust, not to hold them up or otherwise behave opportunistically. And it turns out that people with low discount rates are the most trustworthy. We can see this from the prisoner's dilemma. Players with high discount rates frequently defect because they only care about this round. Players with lower discount rates care about the future rounds and tend to be more cooperative. Many empirical studies, experimental studies demonstrate this to be true. And this makes intuitive sense. For someone that expects to interact repeatedly with counterparties over time, it makes little sense to cheat in the first transaction and thereby forego many future profitable ventures. So in short, the lower the discount rate, the more trustworthy the party, and immortal investors with their ultra-low discount rate should be the most trustworthy and the most sought-after counterparties. Beyond these private benefits to immortal investors, I suggest that immortal investing is in the public interest. And this is essentially because long time horizons and low discount rates imply a concern for the future that is universally seen as virtuous. Think of the fable of the grasshopper and the ant. As a society, we want investors to act like the ant that plans ahead for the winter, not the grasshopper that sings all summer and finds himself starving come winter. Or consider a logging company. We would certainly prefer a logger with a long time horizon and a low discount rate to the opposite, because they would carefully manage the forest as opposed to clear cut today and just grab all the profits. Thank you. And so who shall play the role of the immortal investor? The answer, of course, is the Perpetual Corporation. And I offer towards the end of the paper a few real-life examples of corporations acting in what I view as an immortal type of investments, such as there's a relatively recent phenomenon of the century bond, which is a bond with a 100-year maturity. Obviously, no mortal, no natural person could promise to pay money back in 100 years, but Norfolk Southern can and did. But these examples aside, and I go into a few more in the paper, in real life, the fact remains that corporations often seem to act with a short-term perspective, despite all that I've said today. The primary reason for this disconnect between how corporations should act as perpetual and how they do act is that the owners and the managers are all human beings with mortal time horizons and mortal discount rates. This problem is not insoluble, however. It may be difficult for corporate managers to adopt the perspective of a perpetual entity, especially when shareholders are clamoring for immediate returns. But there are methods that can be employed to try to overcome these hindrances. For example, managers should expressly recognize that they're managing a perpetual entity. Myths, stories, corporate songs, slogans, things like that can help in that regard. And as for shareholders, it is true that they will often try to impose their mortal preferences on the corporations they own, but corporate law takes very good care to minimize the role of shareholders in corporate management. Also, many shareholders of corporations are themselves corporations. Finally, it is certainly true that many corporations, most, nearly all, despite their perpetual existence, do not persist forever. They merge, they go bankrupt, or suffer some other fate. But here's the important point. The important point is that the perpetual nature of the corporation means that it has the capacity to exist in perpetuity, a capacity that we natural persons lack. So even if they're not truly immortal investors, they're the closest thing we have to this theoretical ideal. And if they act as if they are immortal, they will husband and care for the assets under their control, which after the corporation's demise can pass to another perpetual corporation and another. In conclusion, the perpetual nature of the corporation, the perpetual nature of the corporate form has important implications for corporate law and governance. I thank you for your attention. I look forward to your questions. Thank you.
And our fourth young scholar is Houman Shadab of New York Law School, Credit Risk Transfer Governance.
Okay, it's really an honor to be here. Thank you all for coming, and thanks to the organizers and my co-panelists, and just to echo also the comments about Larry Ribstein as well. So my article here is about credit risk transfer instruments, also known as financial weapons of mass destruction or toxic assets. They're often referred to. So the title is Credit Risk Transfer Governance, and I wanted to focus and try to take a scholarly and systematic approach to looking at how credit risk is transferred. Traditionally, credit risk is transferred by taking a credit instrument like a loan or a bond and selling it, or getting a guarantee or some type of other mechanism like that. The more sort of recent innovative types of transactions and structures that do that are credit default swaps or over-the-counter derivatives or securitization transactions by basically bundling up a bunch of loans and putting them into a trust, and then that trust or that special purpose vehicle, SPV, issuing its own debt securities or notes to investors. Okay, so I thought a lot about how am I going to make this systematic, and how am I going to make maybe a scholarly approach to this. What can I connect it to the work that other people have done, whether financial economists or legal scholars as well. And really what I focused in on was looking at governance, generally speaking, but really particular governance by lenders, debtors, or lenders or creditors, also known as creditor governance or lender governance. So that's a type of corporate governance which focuses not on what's traditionally focused on, which is governance by equity holders of large public companies or stockholders. Rather, it focuses on governance by creditors or lenders over companies as well, borrowers or debtors, and focusing on different types of governance mechanisms, not so much shareholder voting and stock markets, as opposed to just monitoring devices, putting covenants, putting collateral, those types of things. How do basically lenders assure themselves of getting some type of return or their money back? And then seeing basically different types of approaches different lenders take in different circumstances. So you can look at an efficiency-based approach from economics side, or more of a legal contractarian approach to say, well, under what circumstances are different contract transactions or structures better for lenders or the borrower. And that I thought made sense because these credit risk transfer instruments, CDSs, CDOs, or other types of securitizations, they are themselves credit instruments. Okay, they expose, there's a creditor side, there's a debtor side, there's a party that's buying credit risk and selling credit risk. So it made sense to me to apply this creditor governance stuff, which is already sort of a minority approach within corporate governance, to these instruments, which are CRT instruments, credit risk transfer instruments, which themselves are credit instruments. And that is basically the story and the setup for this paper. So that's why I think it applies to CRT instruments. So what exactly are the origin of these creditor governance mechanisms in the first place? Well, the reason you have any type of governance, of course, is because you lend money out, or you buy, or you give someone else money and you want to get a return. There are these agency problems, incentive problems, informational asymmetry, so you want to be sure that whoever your agent is, whether they're a borrower or whoever, they're doing the right job for you, they're not absconding money, they're taking enough risk, but they're not taking too much risk. So all these incentive alignment devices, ways that you can monitor and get information about the borrower who's acquiring capital from you, who's exposing you to credit risk, are all different types of governance mechanisms, and they arise and respond to these governance problems. So in the credit default swap type of CRT instrument context, I categorize those as unfunded credit instruments, as opposed to the more traditional type of credit risk transfer instrument or credit instrument, which would be a funded instrument, just like a loan. And so that's the initial theoretical framework I used to divide these two types of CRT instruments. And so basically, funded versus unfunded CRT instruments turns on whether or not the borrower initially gets some type of principal at the outset of the transaction. As in a loan, you give principal to a borrower and they pay you back interest rate and eventually the principal, and some combination thereof. Or with a credit default swap or derivatives transaction where you just start initially by paying those coupons or premiums to the credit protection seller, and then only if there's a credit event, a bankruptcy or default or something, then the principal is shifted down to the credit protection buyer. In the financial crisis, for example, AIG didn't have enough cash on hand to give to Goldman Sachs pursuant to its collateral calls, which weren't credit events per se. So why do I focus on these credit risk transfer governance mechanisms? It's because it's important to focus not just on the bad, on the risks that are created, on the incentive misalignments, on the informational asymmetries. Those are all true in different types of transactions, the conflicts of interest. You should also focus on this sort of cup being half full as well, all the governance devices that are important that parties use to try and combat these problems in the first place. Okay, so in the unfunded derivatives realm, in the credit defaults realm, believe it or not, there is, people refer to it maybe as being chaotic, opaque, non-transparent. These are maybe half-truths or just falsities, I think, or exaggerations, but there are real governance mechanisms in the derivatives world, and they include, for example, posting collateral, just like you would in any other loan, mortgage. There's dealers running a balance book. There's netting mechanisms. There is a fair amount of transparency, and there's also other institutions arising like central counterparties and swaps execution facilities, basically trading platforms. So there is a fair amount of transparency in that market. It's sort of a myth, for example, that it's very opaque, but if you look at AIG's balance sheet from 2000 to 2005, whatever, it fully disclosed on its balance sheet its notional value, in other words, the highest possible risk it had to the credit default swaps that it wrote with its counterparties. It didn't disclose its counterparties and what have you, so certainly more could have been known. But there was no, if you were willing to look and say, look, it's 2005, look at all this risk AIG is exposed to, and it's written on mortgage-backed securities, that could be a problem if ever basically the insurance company is unable to fulfill its insurance obligations on credit, that is, it will go down. And in fact, that leads you to conclude sort of, well, how well is the CDS market governed? And it's actually fairly well, very well, I would think, even prior to Dodd-Frank era reforms or inspired reforms. The only credit default swaps that had a problem going into the financial crisis were the ones written on mortgage-backed securities, or really securities backed by mortgage-backed securities, which were CDOs of mortgage-backed securities, CDOs of MBS, or the sort of synthetic CDOs, which were the super senior tranches of CDOs that were made up of credit default swaps. But in any case, if you look at all the losses that came from the credit default swap market, which were really from AIG and the monoline bond insurers, they're a very small part of the market, about 1%, number one. Number two, a very definable and consistent pattern came across the losses from the CDS market, namely poor governance mechanisms, as I identified earlier, lack of collateral. AIG never posted collateral. AIG, because it was considered AAA rated. AIG never ran a balance book. It was just selling protection like an insurance company as opposed to most derivatives users. AIG was also had its CDS obligations guaranteed by a parent and so on and so on. Not what you typically see in the CDS market. How about securitization, toxic securities, right? Mortgage-backed securities. Well, the only problems in the securitization markets, the really, really bad problems that caused bailouts in the financial crisis, were, again, those certain types of securitizations tied to or backed by mortgage-backed securities. And it wasn't even subprime mortgage-backed securities themselves that were the problem. If we just had more subprime mortgage-backed securities that were inflated and created and deflated and the value went down, we would have been okay economically speaking, but the problem is that the riskiest types of subprime mortgage-backed securities, they were themselves put into additional pools and re-securitized in a second-level securitization, and those were very risky. And their risk was underpriced, and those caused the massive losses, not just to the investors, but to the financial institutions that produced them as well. But if you look at commercial mortgage-backed real estate, CMBS, they did okay. But if you look at collateralized loan obligations, which were securitizations of leveraged corporate loans, unrated corporate loans, or if you look at securitizations of credit cards and of other, almost all the types of assets, they were not impacted at all, or they weren't impacted substantially, and certainly not really underlying the financial crisis the way CDOs of mortgage-backed securities were. And so what are some of the regulatory implications, just to finish up here, is that basically lots of regulation, or regulation itself, is a poor indicator of performance, of outcomes, of systemic risk. Some relatively unregulated transactions led to the financial crisis, but most of the relatively unregulated transactions did not. So you had interest rate swaps, for example, that have been a type of instrument that's been around for a long time, had nothing to do with this financial crisis, and it's a much larger market than the CDS market. In fact, on some level, it's even less regulated because neither the CFTC or the SEC has jurisdiction over interest rate swaps the way they did and they do now over CDSs in terms of fraud enforcement and insider trading and things like that. Same thing with the securitization markets. basically regulation is a poor indicator of outcomes and performance. Vice versa, you can look at on the institutional level, more regulated or heavily regulated banks did very poorly throughout the financial crisis and ongoing. Less regulated or lightly regulated hedge funds did much better, to compare apples and oranges somewhat, than their more regulated counterparts in either the brokerage firm or the banking world. So I go in the paper and I have more specific implications of this credit risk transfer governance idea, which basically says, look, actually these derivatives, they're complex, they're risky, but they're understandable, they're intelligible, and we can look at them more or less ex ante and say, this is going to be very risky, this is going to be less risky, and there's actually ways to increase their governance, put more cash in the collateral, have certain guarantees to make them less risky, and to the extent, though, that people misperceive risk on an economy-wide or systemic basis, those risks and misperceptions and failures to value and what have you, over reliance on models and those other problems, they're going to be reflected, of course, in these CRT instruments, but these CRT instruments themselves are more at the end of the causal chain, not so much causing it, and not really so much contributing to it. So that's, I look forward to the comments going forward, and thank you so much.
Okay, thank you for having me. I spoke at the AALS yesterday on a panel on Occupy Wall Street, and I was booed. So hopefully I won't be booed. Yeah, thank you. 2 for 2. Good trip to Washington. Okay, so I think of myself, even though when I look in the mirror I don't look young anymore, I think of myself as a young scholar, so these are more collegial comments than hierarchical ones. I was actually at dinner with Andrew when he initiated, or this idea of the Perpetual Corporation was just a seed. So I'm very happy to see it have come full circle. Let me respond to, I think, what he makes positive claims and normative claims. So he makes one positive claim is that the reason companies act in the long-term interests, or with an eye towards the long term, is because it's in the statute. I'm not sure I believe that. Another positive claim is that companies are legally required to focus on the long term. Again, I'm not quite sure I buy that. And then the normative claim is that these are a good thing, that companies act in the long-term interest. And again, I'm not sure I buy that. So with respect to the first one, that it's required, you know, and that's why companies act that way. You know, companies can, as he said, elect to be insured. Lots of companies act with more or long, you know, some companies really think about the long-term investments. Some think about very short-term investments or the shorter term. And I don't think any director feels like they're going to be at risk, personally liable, if they focus on the long-term or the short-term. The business judgment rule gives them wide enough latitude. I could start a company today that says this company's going to last for the next 5 minutes. It may serve some useful function in kind of a legal fiction kind of way, that it's like, you know, believing in love. And it's not just sort of, you know, chemical bonds that make us and we're pursuing our self-interest. We sort of wrap it in this nice pretty package, and it's a way that we can sort of order ourselves. But I don't think it's a statutory one, but you know, we could agree to disagree on that one. I think the most interesting part is the sort of normative claims that this is a good thing. And again, the claim must be something like social welfare is enhanced because we have perpetual corporations, or we force companies to act in this way. And again, I'm not sure that's right. We could imagine some empirical tests. Some countries have very long-lived corporations. Japan, Sweden come to mind. Of the top 100 largest companies in the United States, there's only a handful that were alive 100 years ago or existed 100 years ago. In Sweden, almost all of them. So we have a good experiment. We've got a country that's got lots of really long-lived corporations. In the United States, the average lifespan of a company is less than 10 years. So we should expect some differences. We could imagine some empirical test to test whether the US model is something like what economists call creative destruction. The companies are always churning. And that model might be better in some ways. We think about agency costs. He talked about, in the paper, he talks about shareholders and managers, and they're humans, obviously, so they're going to act as mortals. And so you can imagine, he says, well, the long-lived corporation provides a constraint on them. They feel when you go to work for General Electric, you're going to feel like you're doing something for the long term. But agency costs might be higher in that case because there's not as much policing by the market. Companies and people who constantly have to go back to the market to create a new company or get a new job might face a market discipline that may be better than the discipline they get from seeing the founder's picture on the wall. And that's just sort of an empirical question that should be tested. The claims about the investor, the immortal investor, I found the most difficult to wrestle with. And so you think about it, I guess the claim is something like Superman is a superior investor to me. And the reason is if there's something that is going to be an investment I could make, let's say at an oil well, that will only deliver oil in 1,000 years. It's going to take us 1,000 years to drill down to where the oil is at the center of the earth. Would I pay any money for that today? And I think the claim he's making is no, I wouldn't. Superman would pay money for that claim because Superman will live forever, I guess, and he'll invest and he'll see the return in 1,000 years. But clearly I would pay something for that now. And the reason is because it has value that I can then, that future, which is discounted back to me, I can then pass on to someone else. So the idea of what, when I was in the private equity world, we called terminal value, the value of something at the end, the terminal period, that terminal value is positive. You know, when private equity funds or venture capital funds make investments, they think about the long term, even though they're very short-term, short-lived, as he says. You know, venture capitalists invest in startups, the riskiest, most volatile, likely to pay off way in the future. And another empirical test we could imagine is something like looking at venture capital funds, very short-term, by design, 10 years or something, and companies that do venture capital, like Motorola. And I guess the claim he's making is something like the Motorola's of the world who invest in startups will have an advantage vis-a-vis the venture capital funds, and I'm not sure that's borne out. There's a lot more I could say. It's a fascinating paper. I love the idea that I've been teaching corporate law for a long time, and I just sort of never really paid attention to the Perpetual Corporation part. So he's asking the question about why we have this and whether it serves any purpose, and makes an argument about why we have it and whether it serves a purpose. You know, I think I disagree, but it's a fascinating question. Okay. The next paper, very quickly, boy, I think there's like 5 papers in there, at least. And my fear with this paper, I learned an incredible amount reading the paper. It's encyclopedic in some parts, and you know, every page I was learning new stuff and going to the internet and looking stuff up. I got a sense, though, and this is more just like a presentation, an optical recommendation is, I got kind of lost in all the detail, and I didn't really know what your story was. Paul Krugman said yesterday, he's in a spat with some other economists, he said, you know, look, if you want to be heard, you've got to be clear and pointed. And I'm not sure the clearness comes through. So what I want you to do is take all this institutional detail you have and kind of tell a story and get that punchline of what that story is. So as a lawyer, I look at what you call credit risk governance, and I say, boy, that's interesting. I normally think of corporate governance as something that comes from a statute and then a board of directors who's thinking about ordering affairs, and you're saying, no, look, there's this whole other type of governance that exists. Where does it come from? You point out that there were sort of market failures, there were governance failures in some of these instruments. What was the source of those governance failures? Why did some types of governance not work and some kind of governance work? There's a whole debate about securitization that Amit Siru and Ryan Bob and Alex Kaufman have brought some data to the question of whether the securitization process itself led to a decrease in origination standards. That is all fascinating to me. But I like this idea of coming at it from a lawyerly perspective and say, look, there's different types of governance. Where do they come from? Why do these ones work and not work? You know, the really interesting part that you focus on, which not many people have focused on, is there is securitization and derivatives all over the place, and housing is where it really, that's the only part that failed. Leveraged loans for big corporations didn't fail. Credit card securitization didn't have this problem. Accounts receivable securitization didn't have this problem. So you've got this very interesting example where they were using the same tools. What was it about the governance of mortgage-backed securities? And just pulling that piece out and really hammering that, I think would be the most interesting thing. And then, again, from a lawyer standpoint, to ask the question, if we can identify what these market-provided types of governance are, what role is it for the state to either give its imprimatur for some of these things or mandate them? You know, if we mandate them, we have the problem of floors becoming ceilings. Maybe we don't allow the market to develop. The heterogeneity of governance choices is something we should encourage as opposed to picking. Or maybe the government says, we've looked and there's best practices and this type of governance works, so we should impose it on everybody. The move towards clearinghouses is something in that direction. So I think that would make, to sort of focus less on just sort of an encyclopedic recitation of all these types of governance mechanisms and really ask what the question I'm interested in. Why do these governance mechanisms arise, or where do they arise, and how could we encourage more of that private governance? I think is the really fascinating question that your great paper raises. So thank you.
Terrific. So fascinating papers and provocative comments. We'd now love to take questions from the audience, if we have any, and we'll ask you, if you would, to come line up. We have a mic here in the center so that you can be heard by us and by everyone in the audience. So if you can come forward, ask a question. I'd invite the panelists to answer the questions, but also, to the extent you wish, use the questions to jump back to some of the comments on your papers if you'd like to respond to anything that the commenters had said.
David Bernstein, George Mason. First, I'd like to correct Todd just briefly. I don't believe Superman is in fact immortal. He ages. We see Superboy, Superman transition. Plus, he is vulnerable to kryptonite. But my question actually is for Andrew, which is, my sense is that, it's very interesting to think about the Perpetual Corporation, but my sense is when this actually has come up in public policy related context, I remember this very specifically from the 1980s when takeovers were all the rage, that the people who were using the Perpetual Corporation argument, they didn't call it that, it was less sophisticated than that, but we are operating a long-run interest. We're actually primarily short-run oriented owners and managers who were mismanaging their companies and wanted to prevent the shareholders from unlocking value by bringing in people who could actually run the thing efficiently. So the question is, how do we avoid the danger in thinking about the Perpetual Corporation of raise the issue of the fact that the managers and owners are actually also mortals, but aren't they just going to use this Perpetual Corporation argument as an excuse to basically screw over the shareholders?
This is a good question and an important concern. I think you're right. I do think that it's true that if my views here were to become widely adopted, then it'd be very easy for an incumbent management to say, oh, but we've got a plan that in 75 years this company's going to be worth X, and so that's why we're resisting this hostile takeover. I think that that's absolutely true, and it's an important concern. My best and only real response is I think the law is already there. I think Delaware law essentially would permit an incumbent board to say all the same exact things with or without my terminology.
Can I piggyback on the question to Andrew?
Yes.
While you were talking, I did a quick Google search. So I came up with this article from Business Week. Can't say what it's, how accurate it is, but it claims the average life expectancy of a multinational corporation is between 40 and 50 years. And Todd, I think, mentioned even a lower amount for the typical corporation. So that would mean that's the life expectancy, 50s life expectancy in Somalia. And like Somalia, I'm sure also they have very high infant mortality as well as from various forms of combat and in the teenage years. So I wonder to what extent you're kind of making a conceptual argument that doesn't fit in with a functional. That given that the typical life expectancy, even of a big corporation, is considerably shorter than the life expectancy of an average American, the fact that they might live forever, I'm just wondering what logical or practical significance that has. You could make good arguments as to why corporations might be able to do things with a higher discount rate, not because of the lifespan, but because their structure, because they're sold on the markets where future value can get translated quickly into present value, because they don't have the distractions that individuals, humans have. All sorts of interesting questions. I'm just not sure why it makes sense to peg anything on this conceptual distinction that actually doesn't translate, it seems, into a functional one.
I think this is another good question. Thank you, Eugene. My response would be that a corporation that is managed as if it is perpetual, as if it will be around forever, the corporation is just a shell over some real assets and goodwill and factories and such. And a corporation that is managed as if it is going to be around forever, I think will take care of those assets so that even if this corporation is merged into another one or goes bankrupt and its assets are purchased, those assets are in good shape and ready to go for the next perpetual corporation, as opposed to coming to the end of their life. And an example I cite in the article is there's this stuff called Chobani yogurt. It's the most popular yogurt in America. It didn't exist 4 years ago. Some new company, was formed, some new corporation to make Chobani yogurt. And how do you go from making no yogurt to making more yogurt than anyone else in the country? The answer is they purchased a huge dormant facility in upstate New York from Kraft that had been operating it from like 1920 to 2002. Then they got out of the business. Had Kraft taken the view that its life was going to come to a close, then there'd be no reason to keep that facility in such good operating order that Chobani was able to step in and with many millions invested.
Are you sure that's right? Wouldn't it still say, look, if we let this facility burn down, we're going to have to declare a loss on our account books, and our value tomorrow would be less because of that. Because when people estimate the value of a plant, they estimate its value as a going concern, as a potential future concern, no?
I don't know about the accounting, but yes, I think that, so however they get there, as long as Kraft perceives of its goal is to create and maintain and enhance value indefinitely into the future, then yeah, I think that's fine.
Let me just jump in really quickly and just add to that. I think your argument is actually a very persuasive argument in favor of abolishing inheritance taxes. And the reason is that, if there is zero inheritance tax, then I think of myself as living forever in sense of passing things on to my children. The higher, so another way of saying that is, in a world of zero transactions costs, 1,000 individuals and one person who lives 1,000 years are the same. In a world with very high transactions costs about distributing the wealth from 1 to 2 to 3 to 1,000, then there may be some difference. So one question I would just put you on is, what are the size of these transactions costs? What are the sources of the transactions costs? And if you're right that from a social welfare standpoint, we prefer the 1,000 years, we should try to minimize the transactions cost to get the 1,000 individuals to effectively replicate the 1,000-year corporation. That's another way you could kind of come out of the same problem.
Thank you. Let's take another question from the audience.
Yes, hi. I have a question for Houman. Your presentation I found quite interesting, given my background working with the World Bank. And it struck me that when you presented your paper, you mentioned that you mentioned AIG within the context of the subprime mortgage crisis. Now, did you do any research on MIGA? Did you do some kind of a MIGA is the Multilateral Investment Guarantee Agency. Why it didn't fail? Their approach has so far, moved ahead and been successful. And then secondly, with respect to your comment about, I think you said something like regulation was a poor indicator of outcomes and performance. Now, to piggyback a little bit on what Professor Henderson mentioned in terms of zeroing in on a specific area, given the subject matter of what you're presenting, which is governance, what do you see if regulation itself, in terms of carrot-stick approach, doesn't really work? I'm thinking, of course, regulation is a stick, angle of the carrot stick. Did you look into the angle of incentives And what kinds of incentives work in this area, especially in the area that failed, the subprime mortgage?
Subprime-backed mortgage securitization since the financial crisis, the Springleaf Trust, and that has had heavy governance. And that's a good thing, because investors want much more protection going forward, and I think markets learn. If you look at the hedge fund industry, it used to be very, very leveraged before long-term capital management, and subsequent to that, it's much less leveraged because I think lenders to hedge funds, short-term lenders, learned the potential dangers from it.
Okay, thank you.
Thanks.
I'm afraid we've got time for just one more question from the audience.
Eric Clays, George Mason University for Will. I want to make 3 short ones all on the same topic. And Nick can cut me off if he thinks I've gone too long. Under what enumerated power can Congress enact DOMA or some follow-on to DOMA? Is it Article 4, Section 1, or the necessary and proper clause in cooperation with something else? Next one is, under what part of the Constitution do federal courts get to make the kinds of choice of law determinations if there is no DOMA? And then I asked both of those for the third reason. Your article talks a lot about 3 different lines of case law. When you're sorting out which of those to follow and how to prioritize them, are you using the text of the Constitution? And if not, what are you using instead?
Okay. Question 1, what enumerated power? The answer is all of them. Sort of whatever statute it is that deals, since DOMA is a cross-cutting statute, it applies to every statute that regulates marriage. Some of those are under the naturalization power, some are under the spending power, some are under the copyright power. And so DOMA, as applied to each sort of individual statute, is part of whatever enumerated power that is. You would call it necessary and proper, but I think it's really just part of whatever one that is. As for where do federal courts get the power to sort of do the common law approach, I think the answer is the common law approach is really just part of statutory interpretation. So whatever power they have to read and apply a federal statute in the course of deciding a case requires them to figure out what does the word marriage mean. And if they think Congress meant to refer to some state's law, then they have to figure out which state's law. And it's true it's a less directly textual form of statutory interpretation, or it sort of requires construction in addition to interpretation, but it's the same power they have to apply a federal statute in the case in the first place. As for whether the text of the Constitution influences sort of which of the 3 approaches to pick, I think not a lot. I think all 3 of those approaches are ones that Congress could require if it wanted to. Congress hasn't required any of them, and so it really is. I mean, in that sense, none of those are constitutionally out of bounds.
Terrific. Let's please thank our young scholars and commenters.